Peace, kings and queens, guys and goddesses. I really need y'all to listen fully. Bring your attention to what I am saying. This is not about the other party. This is about the impact of a system obsessed with control. I have said it time and time again. I am being harassed. And whether it's under the color of law or not, everything that I have experienced is unlawful and illegal. It affects every area of my life. And more than once, documents that I have submitted to the court, my own evidence, has been turned against me, used as ammunition. And once again, I have the proof. Let the public record reflect. In April 2025, I submitted 3 documents to be filed on the court for an ongoing fraudulently created case involving myself and my minor daughter. Now, the clerk of court, who is required by law to file submissions, returned those documents to me unfiled, claiming I needed to include a certificate of service. Be advised that this is not the first time the clerk of court has failed to file my lawful submission and return them to me. This was despite the fact that I sent a cover letter explicitly stating the documents were to be filed. And let me be very clear. They could have requested the certificate after filing the documents. They chose not to. Now, please stay with me because this is where it all connects. One of the documents that I submitted was titled Notice of Custodial Authority and Non-Consent to Third-Party Interference. I also submitted a cover notice of clerk misconduct and demand for filing documents, which I am going to read to you right now. So I'm going to put the phone down while I read those documents. The cover notice of clerk misconduct and demand for filing regarding unfiled court documents, unlawful returns, and violations of federal statutes. Repeated rejection of lawful filing and federal violations by the clerk of court. To whom it may concern, on May 2nd, 2025, I received a pre-addressed return envelope from the clerk of court for Cuyahoga County Clerk of Common Pleas Court, Juvenile Division. Within the envelope, I found my previously sent notice of claim, notice of custodial authority, and affidavit of non-consent, unfiled with an additional document with the reasoning being proof of service needs to be included. This is particularly confusing given that a previous mandatory judicial notice sent to the clerk of court prior to these documents were also returned to me unfiled, but that document request stated something along the lines of update incorrect case number and express directions for the reasons of the sent documentation. You can now clearly see why the clerk's inconsistency has caused significant concern regarding its legal competence and procedural integrity. This letter serves as a formal notice and public record of ongoing negligence and unlawful behavior by the clerk of court related to mishandling and rejection of lawful filings submitted by me, the living woman, Heaven-Marshay. I have lawfully and repeatedly submitted documents via track certified mail to be filed with this court, including but not limited to the affidavit of non-consent, the notice of custodial authority, and the notice of claim. All documents were properly formatted, verified, and included tracking proof of delivery. However, no record of filing has been returned, nor was any proper filing acknowledgement received. In contrast to the Ohio Supreme Court, returned documents with the notice of filing were received without requiring a pre-addressed return envelope, which confirms such action is not only possible, but lawful and procedural. Therefore, I must conclude that the clerk's office is either grossly unaware of its legal responsibilities or willfully engaging in misconduct and deprivation of rights under the color of law. under the color of law. Please be advised that continued failure to file submitted documents constitute violations of federal law, including but not limited to 18 U.S. Code 2676, clerk's duty to file and preserve records, 18 U.S. Code 1512, tampering with official proceedings or evidence, 18 U.S. Code 2071, concealment, removal, or mutilation of public records, 18 U.S. Code 175.25, fraudulent concealment of evidence, 18 U.S. Code 175.05 and 175.20, interference with constitutional and civil rights, 42 U.S. Code 1983, deprivation of rights under the color of law. This notice is hereby attached to my resubmission, along with updated certificates of service and all required documents. These instruments must be lawfully received, processed, and entered onto the case record without further interference, delay, or misdirection. This document is presented for all public record. If your office will not uphold the filing lawfully and neutrally, you are choosing to violate your oath of office and will be named as a co-defendant in the obstruction of due process. I retain a full record of this attempt, and I reserve the right to publish and pursue federal remedy under Title 42, Section 1983. Although this is not a requirement on my behalf to offer the clerk of court further assistance enclosed, you'll find yet another pre-addressed envelope with covered postage for the return of the filed documents. I reserve all rights and remedies. Should you continue to violate these laws and deny access of lawful record keeping, you will be held liable in your official and personal capacity. Additional notice to clerk. Please give immediate attention to the enclosed affidavit of personal knowledge and conscious warning, which are lawfully submitted and must be entered onto record of case FA 24701460. These are not requests; they are formal notices of record. Should your office refuse, redirect, or fail to file these instruments, such actions would constitute a breach of oath of administrative overreach and may result in both personal and professional liability under federal law. Return these documents to the sender and the indicated proof of filing, with the indicated proof of filing included. Note of intent and clarity. These filings are submitted not in vengeance, but in lawful necessity. They arise from unwavering responsibility to protect my daughter's well-being, preserve our peace, and hold accountable those who continue to violate our rights and boundaries. This action is rooted in truth, compassion, and spiritual duty, not in hatred, retaliation, or personal malice. I have exhausted all good faith attempts to resolve these matters honorably and outside of escalation. My attempts remain protection, accountability, remedy, in full accordance with the law and spiritual conscience. Respectfully, Heaven-Marshay Hope. Living woman, authorized representative, secure party creditor, all rights reserved without prejudice. UCC 1-308, along with my beautiful signature. That was the first document. The second document, the notice of custodial authority and non-consent to third-party interference regarding the declaration of custodial authority for case number FA 24701460. Affirmation of natural and lawful custody. I, Heaven-Marshay Hope, a living, breathing woman and natural biological mother of my child, hereby affirm and declare that I hold lawful, moral, and spiritual authority as sole custodian and decision maker regarding the welfare, education, visitation, and care for my child. I have not surrendered, contracted, nor consented to any third-party custodial transfer, court intervention, or administrative assumption of parental rights. No lawful judgment or verified affidavit has been entered into evidence to lawfully divest me of that rule. Rejection of forced custodial transfer. I do not consent to the coercive or forced surrender of my child to the custody or physical possession of any third party under the color of law, presumed jurisdiction, unverified authority, fraud, intimidation, or emotional coercion. Any such attempt without my My voluntary and informed consent constitutes constructive kidnapping, emotional endangerment, and custodial interference. It may be pursued under applicable federal law, including but not limited to 18 U.S.C. 241, conspiracy against right, 18 U.S.C. 242, deprivation of rights under the color of law, 42 U.S.C. 1983, civil action for deprivation of rights. My child's safety and emotional well-being. I affirm that I have taken independent steps to arrange peaceful, voluntary visitation through Safe and Sound Visitation Center. The opposing party has failed to participate in that arrangement. I am a present, loving, and a protective mother, acting in good faith to ensure the best interest and emotional safety of my child. I am aware of the unresolved trauma and familial dynamics within the third party's household, which may contribute to an emotionally unsupportive or dismissive environment, and I will bring that evidence forward in full at the appropriate time if this court continues to ignore my lawful objections. Lawful demand and standing order. Accordingly, I hereby issue the following lawful demands. Cease and desist all orders, threats, procedures that seek to remove, transfer, or interfere with my child's custody or care. Acknowledge on the record that no lawful authority has been presented to override my natural rights as the child's mother. File this notice onto the court record and timestamp a copy for my personal documentation. Reservation of rights. I reserve all natural, constitutional, and full guardian rights, including the right to seek full remedies and redress for any harm or injury resulting from unlawful interference with my family. Let this stand as law, truth, and public record. Sacred reclamation. I, Heaven-Marshay, a living, breathing, sovereign woman guided by divine intelligence, protected by ancestral power, and anchored in spiritual law, do hereby issue this declaration of custodial authority. This declaration reclaims all rights endowed by the Most High and revokes, rejects, and dissolves all false presumptions, contracts, or administrative claims made against myself or my child. Let this stand as eternal record, both in the physical and ethereal realms. So it is written, so it is enforced. By Heaven-Marshay, authorized representative or represented person done in good faith. With the signed affidavit at the end, as for my beautiful signature. Okay. And as you can see, both of these were filed onto the record. Can you see it? I'm not in the right spot. Give me a second. As you can see, this document was filed May 8th. And this document was filed onto record May 8th. And yet, here's the curveball. The court has done nothing but retaliate since the beginning. They issued a redundant court order instructing both parties to initiate intake with Safe and Sound Visitation Center, a center I had already contacted and completed an intake with on my own. For 6 months, I have upheld visitation independently while the other party did nothing. And hopefully you caught that. In fact, that information was already filed on the record before this so-called court issued order. Now my daughter's counseling services have been suspended. And why? Because I submitted clinical summaries from my counselor and from her counselor to the court as supported evidence of my lawful guardianship and capabilities as her mother. That evidence was received, and in response, the other party contacted my daughter's counselor to request information. Now, based on the illegally issued temporary custody order, services have been placed on pause until new documentation is submitted. Even though I have done everything lawfully, even though I am her only lawful guardian. And it's filed on the record. I am devastated. I feel like my world is being flipped upside down. And I would cry, y'all, but I can't even fathom how much I cry. I cried when I read the email. Oh, I feel so trapped because I don't intend to lie to my daughter, but court is something that I do not believe she needs to know about. I protect my children's innocence faithfully, fully, and divinely. And now I am being forced to tell her that her counseling has to stop, even temporarily. And I know that she loves it. When both of my children depend on it, and I depend on it as their guardian. This is not a small thing. This is our tool for guidance, for safety, for emotional development, and for healing. And now it's been taken. And I am doing everything right. I have built a full evidentiary record. I have cited laws. I have submitted affidavits. I have stayed in alignment. And I still I am continuously harassed, violated, and inconvenienced. We use an emotional wheel in our home to name and understand what we're feeling, so let me share mine. I feel overstimulated, hurt, devastated, violated, frustrated, overwhelmed. I'm anxious. I am scared, disillusioned, confused. I feel ignored. I am so vulnerable. I feel lonely. I feel open. I feel powerful. I feel proactive. And I feel loving. And I hope that it's clear that I am processing a lot. And just when I think I have sent a response and just a moment of peace will arise. It's like it is challenging to shield my children when I am being harassed, wounded, and ignored by the very system sworn to protect us. The very system now causing the greatest distress. And with my primary tool for support now suspended, y'all, I need help. Please understand that I have worked tirelessly on this case. I have done the research. I have followed the very laws this system has sworn to uphold. I show up for every filing, every affidavit, every notice. But this is bigger than just me. I need more attention brought to this experience. If you are struggling to understand, please ask questions. Watch my videos again. Do your own research if you feel called to. I cite laws, rules, codes, and statutes in every video that I have posted for public record as far as my testimony. I am not asking you to blindly believe me. I am asking you to trust experience, including my own, to trust the evidence, and to trust knowledge. Even if you are not there yet, I am asking you to support me. If you can, donate, but only if you can. Share the post, watch the videos, talk about it, because it all truly matters. And we are not free until all of us are free. This is a collective thing. This is not an individual thing. This is not something that you cannot experience. This is not something that is avoidable by consenting. There's tons of fucking evidence that backs that up outside of my experience. And enough attention is not brought to it. We have to change that. Help me change that, please. I have to go.